Hey, it's James, Father's Rights and Resources, hashtag HowiGotCustody. I want to talk about a concept where a judge has a duty to make a reasonable inquiry into the welfare of a child. So, if you understand this is another thing where in the last video I talked about how you need to understand concepts. You need to understand things in the law or in court. People want just a quickie question answered for a surface quickie thing, like, hey, they're asking for attorney fees. How can they get attorney fees? Well, there's concepts about attorney fees, need and ability to pay, the financial circumstances of each party, and the court has to weigh the whole thing. I can't just say yes or no, or you should argue they shouldn't get them. Like, it needs to go deeper than that. So when you understand this concept, you can apply it to all kinds of stuff. The concept I'm talking about, that a judge has a duty or responsibility to make a reasonable inquiry into the welfare of the child. So you're going in front of a judge. A judge supposedly cares about the welfare and the best interest of a child. If the judge cares about the child, then the judge will want to know all the facts of the case in order to determine who's the better parent, what's the best living situation. You can't just say, oh, you guys can have 50-50, or the dad gets every other weekend, just because that's what you always do. It's a court of law where you're going to court to make an argument over who's better for the child. And if you're going to do that, then the judge needs to dig deeper than just people's allegations. If somebody's acute, and a lot of times you can get a concept better if you think of an analogy in criminal court that everybody knows about from watching Law and Order, or a movie that talks about, or depicts a crime, and the trial is the culmination of it, like A Time to Kill or The Client, or, all those John Grisham books that turn into movies. So, or A Civil Action with John Travolta, JFK, Kevin Costner. That one actually has a great closing argument. So when you see what went on with COVID and stuff, and how he wraps up. After you've been in court, when you look at legal movies, you look at them in a totally different light, especially if you've learned some things. So a judge if you're going to trial, in a criminal case, the judge doesn't say, oh, I don't want the jury to see the fingerprints or the surveillance video. Let's just do witness testimony. The prosecutor has the right to present all the evidence that they have available, okay? They're prosecuting a guy who committed an armed robbery or something. They think they have the guy. They have a right to present all the evidence. And for a judge to say, oh, I'm not going to let the jury look at that evidence, unless it's inadmissible or it was obtained without a warrant or illegally, they want to get to the truth and the facts of a situation. So they're going to want to look at all the evidence, right? They would never say, oh, I'm not going to even look at that. You got, like if they would have told in the O.J. Simpson case, that trial lasted like 9 months, I think. If they would have told the prosecutor, you got 3 weeks, then that would be ridiculous, because they have a chance to present all the evidence, all their experts, and then O.J. was able to provide his counter. The judge can't just stop and say, oh, you got a few days. But they do that in family court all the time. But if you know this concept that I'm talking about, I would be telling the judge, like at a pretrial conference, my baby's mom says, I need 2 days for trial. And I say, I need 4. And they're like, what are you talking about? You're not an attorney. You don't know what you're doing. I've gone through the evidence, Your Honor. I've looked at all the evidence. I really could get up there and talk for a week all by myself, but I'm trying to consolidate it. And you have a duty of care and responsibility to the child, first and foremost, to make a reasonable inquiry, meaning whatever's reasonable, not outrageous where we're in court for 5 years, but whatever's reasonable, a reasonable amount of inquiring into the welfare of the child. So that means you're going to reasonably look into all the evidence. The mother has a right to present her evidence. I have a right to present my evidence, especially if she petitioned the court, or she filed for a divorce, or she filed for a custody case. My constitutional right to my kid is on trial. And if I have a constitutional right and my freedom on trial, including restraining orders, taking my home, taking all these things that I have a liberty interest in under the 14th Amendment, Now, if you don't understand any of the stuff that I'm talking about, you need to get a consult so you can fully understand it. I'm giving you an overview here, and this is another example of stuff you get out of a consult with me. I was just talking to a guy earlier. This guy is on top of his stuff. He's had several 30-minute follow-ups with me after the initial consultation, and he's got his stuff down. He'll call me, and he'll talk about case law or what trial is coming up, and he'll just get tidbits here and there. That's the whole purpose of me having a consult with people for an hour and a half and then doing follow-ups. They could do at least 30 minutes. A lot of people need more. But if you're on top of it and studying hard and really preparing for court, then you might just need a little brush up or here and there in the follow-ups. But initially, everybody needs an hour and a half. So the guy I was talking to today, he's talking about certain things that he's preparing for trial. He's going through discovery. He's got a couple hearings coming up, or one hearing coming up. And I was telling him, I would tell your judge to make sure that I have enough time to present all my evidence, because you have a duty of care to make a reasonable inquiry into the welfare of the children. Think about it. The judge, put yourself in the position of the judge. If I'm trying to find out what's best for this child of these two total strangers, I don't know them, I need to know all the evidence that the mother's going to present and that the father's going to present, and maybe a guardian ad litem, and I need to gather it all together and balance it out and then come up with the decision. That's what a jury does in criminal court. That's what a jury does when you sue a doctor for malpractice. I looked at the doctor's witnesses. I looked at the patient's victim, the victim or the patient or the alleged victim. I looked at all their witnesses and their testimony and their evidence, and I saw expert testimony. Now I need to make a decision based on all the evidence. A lot of times at a pretrial hearing, the judge will say, like I was giving an example, the mother says, "Oh, I need 2 days to put on my trial," and let's say I say 4. They say, "You got no more than 1 day." I would tell the judge, "How can you tell me how much evidence I have before you even look at it? I've looked at the evidence. I need 4 days to present it. I'm going to testify for a full day. I'm going to put the mom on the stand for a full day. I got 2 other witnesses that'll last 2 hours and a couple that'll last 30 minutes. In Washington, we actually have a witness list where you break down the time you expect them to be on trial or on the stand or whatever. And then I'm going to say, Your Honor, this is all evidence. See, when you know these different concepts, you can put them all together. I have a fundamental fairness doctrine right. That's a constitutional right to prepare for trial and to be fully heard. In order to be fully heard, I have to present all my evidence. And then on top of that, I have a constitutional right of access to my child at stake. So I really have a due process right to present all the evidence against me and to defend myself and to speak. And I'm telling you, I need at least 4 days to do that. And I will get it on the record in a pretrial brief or whatever. And this is where people don't think. They don't get a consultation with me, and then they call me after their trial, after they get screwed. I'm like, "Did you put this on the record? Did you put that on the record?" Well, you can't appeal because you didn't make that argument on the record. But I'll put it on the record. In order for me to have a fair trial, I need at least 4 days. And then the judge says, "Nope, you got 2 days." Then I would write an objection. I object to only having 2 days on trial. I have laid out that I need a day to tell my story. I've practiced it. I need a day to question the mother. I need half a day for these witnesses, half a day for that. And the judge has a duty of care to the child to make a reasonable inquiry into the welfare of the child, meaning they got to look at all the evidence. None of the evidence should be hidden. The guy that I was talking to, there was some therapy records that he thinks are going to be hidden, and he's not going to be allowed to see them. If the therapy records affect the child and how the child is doing, or talks about how the child is doing, that's something the judge should see. And if the judge sees it, I should see it, because I'm defending myself and my constitutional right. See, when you know all these different parts, you can put all this full argument in. But most of you want to totally half-ass this and get a quickie question or a quickie answer because you're lazy, because you live in a Microsoft fast food drive-through touch button generation, and you think that you don't have to be thorough in the war over your kid. You are in a war. This isn't a joke. This isn't a light, quickie little run through. You're in a full-blown war over your kid, and you want to use everything that's available and all the understanding of all aspects of the law that you can get in your head and understand. Fundamental fairness doctrine, right to be heard. The judge has a duty of care to the child. The judge has to maintain the public's confidence in the judicial system. The judge has a duty to conduct things in a reasonable manner. And, they have to exercise judicial economy, but at the same time, balance out their full inquiry, not a half-ass inquiry. and then they need to make a ruling. And if they don't allow that evidence, they can't make a fair ruling in the best interest of the child. So that's just basic legal 101 stuff I'm talking